The ground has just shifted beneath our feet. While the media obsessed over trivialities, a revolution was taking place in the courts, quietly, methodically. A series of bombshell rulings have just rewritten a century of American gun law. The rules have changed. Radically. This isn't a minor adjustment, it's a tectonic shift in the balance of power between the citizen and the state. The legal landscape that has governed your life for decades has been completely redrawn. The era of government overreach and bureaucratic control over your most fundamental rights may finally be coming to an end. In a stunning cascade of legal decisions, federal courts have systematically dismantled the complex web of restrictions that has suffocated the Second Amendment. Laws once considered untouchable have been struck down. Rules that gave unelected bureaucrats immense power over your life have been declared unconstitutional. This is the story you won't hear on other networks. They don't want you to know how much has changed, or the new power you now hold. For generations, Americans were told their right to keep and bear arms was a conditional privilege, a favor granted by the government. You were treated like a subject, not a citizen. But the courts have now sent a clear message. The Second Amendment is not a suggestion, it is a right. These changes will impact every gun owner in America, and every citizen who believes in the Constitution. This isn't just about guns, it's about liberty, about whether you are sovereign over your own life. The story of these 10 quiet legal revolutions is the story of freedom being clawed back from the brink. It is a story of power returning to the people, where it has always belonged. And it starts now. For decades, courts gave the government the benefit of the doubt when it came to the Second Amendment. They allowed your right to self-defense to be chipped away with flimsy excuses and junk science. That game is now over. The most profound change is the judiciary's new commitment to applying strict scrutiny to Second Amendment cases. Now, when a law restricts your right to own a firearm, the burden of proof is on the government, not you. They must prove in court that their law is absolutely necessary, not just convenient. This simple change is a fortress for your freedom. Before, a state could ban a whole class of common firearms by simply claiming they were unusually dangerous. Now, that's not enough. The government must provide overwhelming evidence for its claims. The days of lazy, rights-infringing legislation are numbered. Lawmakers must now think before they legislate. Every new gun law will be viewed through a powerful constitutional lens. Is this law truly necessary? Is it the least restrictive means possible? Does it respect the citizen's fundamental right to self-defense? For the first time in a very long time, the Second Amendment is being treated with the same respect as the First. The government is no longer the default winner in court, the Constitution is. This is the foundation upon which all the other victories are being built. For as long as anyone can remember, there's been a glaring double standard in American gun law. One set of rules for you, another for government agents and retired law enforcement. Laws like LEOSA created a special class of citizen with more rights than everyone else. Recent court rulings have taken a sledgehammer to this unjust system. If the Second Amendment protects an individual's right to own a particular firearm, that right cannot be limited to a select government-approved group. The courts have now affirmed if a firearm is suitable for law enforcement, it's suitable for a law-abiding citizen. The Second Amendment was not written to create a privileged warrior class. It was written to guarantee the rights of the people, all the people. This principle is a restoration of equality under the law. The government can no longer tell you that you are not worthy of owning the same tools for protection that it provides to its own agents. The Second Amendment, the great equalizer, is finally being applied equally to all. Red flag laws were meant to remove firearms from dangerous individuals, but in practice, they became a weapon to strip citizens of their rights without due process. Secret hearings, no legal representation, and property seized based on a single accusation. This was the reality. The courts have now stepped in to halt this constitutional nightmare. New rulings have established stringent due process protections for any American facing a red flag order. There can be no seizure of property without a fair and open hearing. The accused must have the right to face their accuser, present evidence, and be represented by counsel. Secret, one-sided proceedings that result in immediate confiscation have been declared unconstitutional. The government cannot strip you of your rights based on a secret accusation. Thanks to these new court decisions, that system is dead. Now, if the state believes you are a danger, it must prove it in a real court, with real evidence. This is the restoration of due process. Emergency measures can no longer be used as a backdoor to disarm law-abiding Americans. Your rights and your property are no longer up for grabs. For decades, anti-gun politicians have sought a national gun registry, a federal database tracking every firearm and gun owner. Federal law explicitly prohibits such a registry, yet agencies like the ATF have built de facto registries by amassing records. The courts have finally brought the hammer down. In a landmark privacy ruling, federal agencies have been ordered to cease the consolidation and digitization of firearm transaction records. The ATF's billion record database was found to be a clear violation of federal law and privacy rights. The government cannot be allowed to build a list of gun owners, a tool that has historically been a prelude to confiscation. The courts have recognized this danger and acted to prevent history from repeating itself here. This victory for privacy is a massive blow to the gun control lobby. The ruling protects the privacy of millions of Americans who believe their ownership of a constitutional tool for self-defense is their own business. Privacy is the boundary between the individual and the state, and that boundary has just been reinforced with steel. The government's appetite for your data is limitless. In the digital age, they found new ways to monitor law-abiding citizens, like pressuring credit card companies to flag gun-related transactions. This was a warrantless backdoor surveillance program targeting millions of Americans. The courts have declared this practice a gross violation of both Second and Fourth Amendment rights. Federal agencies are now forbidden from using financial intermediaries to conduct mass, warrantless surveillance of gun owners. Monitoring the purchase of a constitutionally protected item is a form of intimidation and an infringement on the right itself. If the government wants to investigate, it needs a warrant, period. Under the old system, legal activities could have resulted in your name being added to a federal watch list. This created a chilling effect, discouraging people from exercising their rights. This ruling restores a critical element of privacy and freedom. You can now buy firearms or ammunition without worrying your credit card company is reporting you to the government. The court has sent a clear message: exercising a constitutional right is not suspicious activity. The government's desire to watch everyone is not a blank check to ignore the Constitution. In many states, the right to carry a firearm was a right in name only. May-issue systems let local officials deny permits for any reason, turning a constitutional right into a privilege. The Supreme Court and lower courts have now ended may-issue regimes nationwide. States must now adopt shall-issue systems. If you meet the legal criteria, you get the permit. The discretion of the local official is removed. The decision is based on law, not whim. This is a monumental victory for equality and the rule of law. The abuses of the May-issue system were notorious. Permits went to the wealthy and connected, not ordinary citizens. Now, that system has been dismantled. Your right to self-defense is no longer subject to the approval of a police chief who doesn't know you. This change ensures the Second Amendment is a right for all, not just a perk for the elite. It restores fairness and predictability to the process. Your safety is your right, not a favor to be begged for. For too long, the ATF has acted as judge, jury, and executioner for thousands of honest gun dealers. Small business owners lived under the threat of losing their licenses for minor paperwork errors. The courts have now severely curtailed the ATF's power to arbitrarily revoke federal firearms licenses. The agency cannot revoke a license for simple, non-willful paperwork errors. There must be evidence of deliberate intent to violate the law. This change forces the ATF to distinguish between genuine criminals and honest business owners. It ends the era of gotcha inspections designed to entrap gun dealers. This is more than a procedural change. It's a restoration of fairness and a check on bureaucratic power. It ensures FFL holders are treated as partners in public safety, not presumed criminals. Business owners can now operate with certainty, knowing their life's work can't be destroyed by a vindictive agent or innocent error. The law now protects the backbone of the firearms community. The courts have addressed two of the most illogical federal regulations: the classification of stabilizing braces and the extreme regulation of suppressors. The ATF reclassified firearms with stabilizing braces as short-barreled rifles, turning law-abiding citizens into potential felons overnight. Suppressors, simple safety devices, were treated as if they were machine guns, requiring a months-long process and a punitive tax. The courts have struck down these absurdities. The ATF had overstepped its authority and engaged in illegal rulemaking. A piece of plastic cannot transform a legal pistol into a highly regulated rifle. Suppressors are now recognized as arms protected by the Second Amendment and as safety devices. The impact is immediate. Veterans and families can use these accessories without fear of prosecution or bureaucratic delay. The court recognized that promoting safety is not a crime. These decisions represent a triumph of common sense over bureaucratic inertia and anti-gun hysteria. The courts have looked past propaganda and evaluated these items for what they are: accessories that make firearms safer and more accessible. The Constitution and common sense have prevailed.